First, about your presentation. I'll come back to that later, but what seems interesting to me in the case of these Scandinavian countries is that the rules of constitutional adjudication are very different from the rules of constitutional adjudication in the United States. According to good specialists of the American constitutional law, notably my colleague at Stanford, Jack Rakoff, the origin of the American judicial review, more than in this famous and for a long time irrelevant decision, Marbury versus Madison, the origin of judicial review in the United States has to do with the federal structure of the political system. 99% of the law cancelled by the Supreme Court in the 19th century were state laws, as has been said this morning by Jean-Louis. I mean, only 2 federal statutes, the one in Marbury versus Madison for complex reasons, and then later on for even more complex reason in Dred Scott. Dred Scott is a very obscure case from the technical point of view. He's even not sure that the Missouri Compromise was a statute law. So de facto, the entire origin of the American judicial review seems to be connected with something which is inevitable in a federal system. You need a court adjudicating legislative competencies between the states and the central government. Now, this story has nothing to do with your countries. Iceland, Norway, Sweden are not federal systems, or in the French style, centralized legal system. They are kids of the French Revolution which killed the Girondins in Saint-Émilion. Now, there is another route of constitutional adjudication, and here's my question. The other route, as Kelsen says quite clearly, which is the classical foundation of the European constitutional adjudication, is administrative law. If we reread accurately the text he presented first in Vienna and then in Paris in 27-28, Kelsen suggests that constitutional adjudication is actually nothing more than developing the idea that courts adjudicate hierarchy of norms between legislation and administrative acts. Le contrôle de l'égalité is not an American invention, it's a French invention. And there is no administrative courts in the United States. This separation between administrative adjudication and other form of conflict resolution is a French invention. And Kelsen, who did not know anything about the United States or England, but a lot about France, claims that logically, in his system of hierarchy of norms, what he's suggesting is to develop the French system, moving up the control of the hierarchy of norms from the one between legislation and administrative act to the neo-constitutional approach controlling the hierarchy of norms between the constitution and the legislation. So that by the way, Kelsen insisted also on the role of federalism in constitutional adjudication, because Austria, even under the empire was a federal system. Constitutional adjudication from the federal point of view, by the way, existed already in the Middle Age in Germany, in the German Empire. There was a court in Konstanz and then in Goslar, the Reichskammergericht, which was in charge of the conflicts between the empire and the Kingdom of Bohemia, the Archbishop of Mainz, so this subunit, an equivalent of the European Court of Justice for the European Union. I mean, that existed in the 14th, 15th century. So, okay, now, my question is, do you think that one reason of the development of constitutional adjudication in Scandinavian countries has to do with the fact that for a large part, not entirely, but for a large part, these countries knew administrative adjudication? My question is double. Where there isn't administrative courts in your countries? Everywhere or not everywhere? Sweden has administrative courts. Norway? No. Iceland? No. So, and then, which is the role of this administrative adjudication in the development of constitutional adjudication? That's one first question. The second question has to do with the Norwegian experience. Because Norway has been said, has a long tradition of judicial review, starting in the 19th century. So Norway is the first country in the world after the United States which had some experience of judicial review. But as far as I understand, there was a period of quite active judicial review, and then a decline. My feeling is that the decline has to do with the political history of Norway. Because if I understand correctly, in the 19th century, the Supreme Court was protecting property rights and rights of elites. Then with the development of social democracy, the social democrats became so prominent and so powerful. I mean, Norway is a country where there was no alternation in power for almost 70 years. The epitome of a despotic regime, but Norway is so strange that what looks like a despotic regime is not a despotic regime. But then the court was marginalized. So this is interesting because I've been always fascinated by the political theory of constitutional adjudication, and the left in Europe is divided in three branches. Communists have always been very hostile. The most interesting example of this explicit hostility is the position taken by the Communist Party in the Italian Constituent Assembly in 46-47, where they, being seriously French Jacobin, are absolutely hostile to any form of judicial power. Very different is the position of the German-speaking Social Democrats. When the Constitution of Austria was debated and voted in 1920, there was an unanimous agreement about the introduction of a constitutional court. And notably the Social Democrats. Kelsen was called by the Chancellor Renner, a social democrat, to write this section of the Austrian constitution. But I checked, the idea of a constitutional court was accepted in the political project of all the parties in Austria. And in Germany, the social democrats were always favorable. That's not the case in the Scandinavian countries. So there is a tripartition of political position vis-a-vis constitutional adjudication. In Southern Europe, meaning Italy, Spain, France, enormous hostility. The few communists even opposed any form of constitutional adjudication in France until 2 years ago. They are still against. So that's the communist position. That's adamantly Jacobin and enemies of the judicial power. The German-speaking social democracy is favorable. The Scandinavian is trickier. So, okay, but I'm stopping here. What I want to know, first, the role of the administrative adjudication, and then something more, if possible, about Norway and the attitude of the left. I know, for instance, that in Sweden, constitutional adjudication was supported very positively by the conservatives. I think that this, which is a bit connected with Charlotte's presentation, the connection between this form of state action and political position is quite interesting, has been not analyzed in general, because legal theory ignore politics, and politics doesn't understand law. So we don't have a theory of all that because of this disastrous division of labor, of which Kelsen is responsible largely. Because before Kelsen we had a discipline called Staats- und Verfassungslehre, which was able to discuss this book. But now political science ignores legal theory. Legal theory wants to be pure, so it's ignorant of politics, so we don't understand anything. Okay. So please react if you want.
Shall I start or?
Oh,
You start?
yeah, you start. I'll just.
So first of all, because even when you look at Kelsen, his focus is not on individual rights, is it? It is is functional.
Yes.
So and of course it's within the federal system, but it could also be functional within a non-federal system, but it is functional in the bodies of state and competences, etc.
Yeah.
In the Norwegian context, one had, well, again, the judicial and the political administrative function. How separated was it at the beginning of the 19th century? How separated was it in the 18th century? Of course, it goes. It separates, but it merges in certain areas. You know, Austria is a good example. They join the local first instance courts, don't they, with administrative power, and again in sometime in the mid-19th century. You know, these things move, and of course we know the relationship between the judicial and the legislative. That too moves. So in a sense, when we're looking at it today, where we have our clear concepts, and we just transpose back in time our separation, which was not obvious for Montesquieu, and definitely not for Montesquieu's contemporary, and probably not for the next 100 years either. You know, so that's the kind of relativism one has to take account of. I think that it probably wasn't all that clear, you know, in the 19th century Norwegian courts. The functions, they were central bodies of state, the parliament, the executive with its ministries, the regional préfet equivalents, and the courts. You know, they were overlapping. I don't think it was that clear. So I think that's an important background, you know, to have. And that's also perhaps why Aschehoug could write then in the 1860s, 70s, when he wants to transpose Marbury and Madison. It had hardened, it had become clearer at the end of the 19th century than it was perhaps in the beginning of the 19th century. And he could then advocate adopt Marbury and Madison. Probably in 1820 they said Marbury, or 1830 Marbury and Madison. Yes, fine, that's what we're doing, probably, without questioning it. You know, what a strange separation they have there. You know, and then to the political side. And again, I think one should be enormously careful in over-rationalizing, because I think some of these positions, which you mentioned, are taken just then and there. I'm sure that there would be times in the 1950s where you could talk to a French communist who would find that, of course, he hated the court review, but it was enormously important in securing individual liberties. You know, the important Conseil d'État decision about the access of, or was it communists to ENA, wasn't it? You know? Yeah, exactly. You know, so these things are very significant. But of course, constitutional review after the war. Well, what was that about? The whole European Convention has been presented as a Cold War measure to avoid the or to create obstacles for a communist takeover. You know, in a sense. That's an alternative story, which is quite relevant. Why did it come in 1950? Why did the UN Covenants come in 1966 and the European Convention come in 1950? And if you were a social democrat, socialist in the Scandinavian tradition, you know that the courts are bourgeois, they will protect property, they will protect established positions, and whatever power you give them will be sand in the machinery of democracy and justice in a higher way, you know, social justice. So you see their position. So there's a beautiful story. If you haven't read it, you must read it. It's just being translated to French, I think. It's a biography of Olof Palme, Wonderful Days Ahead or something like that. And he comes in as the young assistant of Tage Erlander in the 1950s, and in 58 or something like that. The Conservatives say, and this is on the basis of the European Convention, we must have an extensive rights catalogue in our constitution. We want constitutional reform. And the Social Democrats find this immensely difficult, because they can't really oppose rights. But on the other hand, they don't want to have new obstacles then to what they see as social reform programs. So Palmer then, as the young assistants thinking about this overnight and come back in the morning, excellent, say yes. And say that we will also propose social and economic rights catalogue in parallel with the civil and political rights, which Tage Erlander, the Prime Minister, does, and the Conservatives immediately withdraw their proposal. So, you know, the Cold War was the same, wasn't it? Social and economic rights, not focus on judicial enforcement. Civil and political rights, focus on judicial enforcement. The communist, the third world perspective, the conservative, the rich world, the Western perspective. And then it's only then in the 1980s and 1990s when these perspectives, it starts in the 1970s, but in Scandinavia, where both sides of the political spectrum accepts rights. And then I think today it is again very situational who opposes the rights adjudication and the strengthening of that. So, for instance, the agrarian parties would oppose it generally, because they have local authority power in certain areas, and they find that rights would mean centralization, because it's at the national level and it allows less regional decision making. And then it is the extreme right, because they are worried about immigration. You know, so, and then you have the right again against social rights, and then you have the left, who still are concerned about courts being conservative mechanisms. But I think these positions change all the time. So I think if you're going to analyse it, you have to take account of how unprincipled and how short term. And then at all times you have people who feel, and particularly lawyers in the Scandinavian model, because it's been very kind of academically law dominated, central bodies of the state who would oppose the freedom of action. You know, you want discretion, freedom of action, political freedom of action. You see your role as a lawyer to secure the politicians' the maximum freedom of action. And again, that's perhaps the only continuous institutional point of view somehow. I think all the other things have been changing. But I had one other thing I would like to add, and that was that the Swedes then, first of all, introduced an explicit provision about court review then in the 1990s, and then took away this threshold, that it had to be clear breach or whatever it was. But as you said, they had the provision taken in now that the courts have to take account of the role of the people through exercising legislative power through the legislature and democracy or something like that. In the Norwegian constitution, they had an amendment in this year where they took away the role of the state church, because we had this Lutheran state church, and then they introduced as a kind of new article of faith, rule of law. And rule of law, of course, then to some extent follows what happens in all other constitutions. But the way I have interpreted and wrote about it before, and I think the parliamentarians accept, that means, for instance, that the previous constitutional review of legislation by courts based then partially on the constitutional system, partially on constitutional customary law, that now has an anchor in the constitution. And then in the proposed new provisions with the rights catalogue, there are two, that's proposals, which will be adopted one way or another in 2 years' time. It's a long time lag in our constitutional amendment procedure. And then there's two alternative formulations, and one just says courts review. Courts review and then set aside legislation. No qualifications, modifications. And then the largest faction in the committee dealing with this in Parliament were casting around because they wanted, and they'd seen the previous Swedish provision. They weren't aware of the amendment, and they thought, well, we need some kind of. And then one of the academics, of course, I think Eric Smith had said, we must be cautious not for too much court review. And then, unlucky for him, of course, they didn't ask him to come, but they asked me to come. And I then proposed, well, I think as it was unproblematic with the provision as it stood, but if they wanted an alternative provision, and then I showed them the Swedish, and then I said, one of them knew it, and they immediately supported that. And I said, but in the Norwegian context, we also have to take in the reference to the rule of law provision. So now the two alternatives, just court review, no modifications, and an alternative which says court review taking account of the constitutional principles, which include, and then there's a reference to the people in the lawmaking process, people exercises the lawmaking function through Parliament, human rights, and the rule of law. And then I thought, any court will do that, there's no limitation on that. So they're going to adopt one of the two, and they're not going to have any restriction the way the Swedes then had in the 1990s. So I think now, whatever you say, it's not only the question of the legislature accepting this, but it has now been given quite pregnant expression then in the Swedish constitution, in the Norwegian already, and it will be even more expressed and even clearer in the Norwegian. So opportunities and a better legal base are my two answers.
Thank you very much. I have other observation on Charlotte's presentation, but I think that we should now ask Sarah to speak about Netherlands, and then we will open up again the discussion. Please.
Hopefully, Annette, thank you all for her presentation. Invitation, and she's very sorry that she couldn't be here. Now, she is not Dutch, neither am I. We're both Belgian, from the Flemish part. And so we asked ourselves what would be the added value compared to a presentation given by a Dutch scholar about his own legal system. Now, I think the answer is the following. A Dutch scholar would give you more or less the same facts as I will give you. I will explain the constitutional framework, but the difference lies in the fact that the Dutch scholar would most likely represent the outcome as self-evident. Now, the outcome is the Netherlands is doing very well, it's a democratic system, the legislator is respected, no one's really complaining, and therefore most would say that there's absolutely no need for constitutional review by the courts. Now, perhaps as an outsider we should respect this, Undeniably, there's major democratic issues. Constitutional courts are political actors, which demands caution. But on the other hand, in the Netherlands, there is a legitimacy crisis, as elsewhere, with citizens losing confidence in members of parliament, with more extreme and populist political parties winning votes. So why is there no desire for some constitutional counterweight, if only from a purely academic point of view? Now, how can the paradox be explained that the Netherlands is unconditionally transferring power to international actors rather than to their own judges, who might protect Dutch values and interests against European scrutiny? Now, let me first start with the facts. First of all, the constitutional framework in the Netherlands. First of all, I would like to clarify that this presentation only deals with the situation in the Netherlands. Within the Kingdom of the Netherlands, there are three of the islands which have established a system of constitutional review, but I will not discuss that today. So the Netherlands is one of the very few countries where the Constitution explicitly prohibits good courts to review primary laws against the Constitution. As you can see on the slide, this is provided by Article 120 of the Dutch Constitution, and a similar provision, as was explained in the introduction, was already inserted in 1848. Now, as a consequence of that, courts are not allowed to review statutes against any provision in the Constitution, examine whether the lawmaker complied with procedural requirements, and thirdly, the Supreme Court itself declared in the decision in 1989 that it also implies a prohibition to review statutes against the Charter of the Kingdom or unwritten legal principles. Now, the constitutional ban applies to statutes, but not to secondary legislation. But then again, review of secondary legislation may not amount to indirect criticism of statutes. For example, if the rule in a subordinate law that is considered to violate the Constitution flows directly from the parent act of Parliament. So there's a clear ban on constitutional review, but there's a fundamental nuance, which is the fact that the courts do have the power to review statutes against international law, which is provided by Article 94 of the Dutch Constitution. And this power was inserted in the Dutch Constitution in 1953, and it expresses the monist position of the Dutch legal system in its relationship with international law. Now, according to this clause, international law has priority over domestic statutes, but also over the Constitution. Quite a radical position in present debates in Europe. Now, there's only one limitation, the specification, which was added in 1956, stating binding on all persons. Treaty review is thus combined to those norms that are sufficiently clear to allow enforcement by the courts without legislative intervention. So, as a result, Dutch courts are under the obligation to review acts of Parliament against fundamental rights and other